Good morning, everyone, and thank you for being here today at our webinar to review Threat Assessment 2022. I'm Dana Fattore Crumley, and I'm here with Amy Dickerson, and we are going to do a really fast but hopefully meaningful half-hour presentation on just a review of the requirements for threat assessment procedures and some changes to the law that were recently enacted. I know this has come to everybody's mind this summer because of some very tragic events that we've all lived through. First with the Uvalde shooting, and then with the more locally with the shooting that happened at Highland Park. Although that was not a school event, many school children were impacted by that. And just the threat of violence generally is something that's very much on everyone's mind. So that highlights the importance of everyone refreshing themselves on what the requirements about this are and making sure that the procedure that they have in place and what you're actually doing in the building is meaningful. And as we start off on this topic, I think it's not only to prevent these horribly tragic events, and there's a benefit in doing this to try to work to identify issues and address them before they become a tragedy, but also just to connect with kids. I think we should think about this as not something that is so aberrant and is so sort of outside the norm, but also making sure in this time after the pandemic that we're really looking at all kids and their needs and seeing when they may be susceptible to having, feelings that they can't manage and bringing them in to service and to intervention in the school through this process. So I see of it as both something to address these tragic events, but also something that is just best practice to capture some of the social emotional needs of the students in the building. So I just want to remind everybody of what sort of, if you have questions as we go through, to add those to the Q&A feature. We tend to monitor that more closely than we monitor the chat, and it's easier to keep track whether or not we've answered the questions. So you can just add your questions into that. We'll also take some time at the end of the presentation to answer some questions and take comments from people. The other thing is the threat assessment procedure, which is really the bulk, it addresses the bulk of the requirements under the statute. We do have a model one, and if you'd like more information about that, you can reach out to either me or Amy or anyone that you work with at Franczek after this presentation. So Amy is just going to get us started with a reminder of where we started.
Yeah, so back in the beginning of the 1920 school year is when the School Safety Drill Act, which goes through and still does have all of our requirements for all the different safety drills that schools have to do on an annual basis. That was amended at the beginning of the 1920 school year to require that school districts implement a comprehensive threat assessment procedure. And I will go through in a little bit here what the requirements were as to what needs to be in those particular procedures. But nevertheless, that was required then to be put into effect at some point, at a date during the, I think it was now sort of like the later part of the winter of 2020. So needless to say that the dates there are a little significant in that I think there was a lot of obviously momentum to really make sure that districts were complying with this new requirement and really taking an in-depth look at what their threat assessment protocols and procedures are, which we'll talk about the difference of in a bit here. But then of course, with the pandemic and schools largely going remote for a long time, there was, this is understandably might not have been at the forefront then of folks' minds for a while. So we, thought for the reasons that Dana just went through and just given that we're now getting ready for the start of the school year and that there have been some new updates to the requirements for the procedures, we wanted to go through what those are. So with that, I'll go through in a bit here what's actually required to be in the procedure. But in addition to requiring that districts implement a threat assessment procedure, there were two recent public acts that went into effect this past May that made some additional changes and amendments to the requirement. So one has to do with confidentiality. So it was already provided under FOIA that records concerning the work of the threat assessment team of a school district were exempt from FOIA. Under Public Act 102-791, now FOIA is further amended to state that those exempt records include, but aren't limited to, any threat assessment procedure under the School Safety Drill Act, as well as any information contained in the procedure. So with that amendment, we have it very clear that the actual procedure itself, including those individuals who are part of the threat assessment teams, are exempt from FOIA. So, one question we often get is, should our procedure that we are adopting to comply with this requirement be part of our board policy? And in light of this expressed exemption under FOIA, we think it is a best practice to not have this be part of your board policy, but to have it be, part of your procedures and administrative procedures, so that not only can you make modifications when you need to do so in a more easy fashion, but also then you're not waiving your ability to be able to, keep that confidential, or at least outside of the public atmosphere, to the extent that you want it to do that, to the extent that your procedure is quite detailed in terms of how you're going to be assessing different potential threats. In addition, there was another public act, 102-894, that now really requires charter schools to also have these threat assessment procedures. So specifically, it requires that a charter school either follow the threat assessment procedure that's implemented by its authorizing school district, or the charter school must implement its own threat assessment procedure that complies with all the requirements under the School Safety Drill Act. And then additionally, and probably kind of the most significantly in terms of things to do for those of you that are listening, is Public Act 102-791 requires now that, in addition to having our threat assessment procedure, that each year, starting with this school year, prior to the start of the school year, each board must file their threat assessment procedure, as well as a list identifying the members of the school's threat assessment team, with not only their local ROE, but also with local law enforcement. And then for Chicago Public Schools, instead of filing that with the ROE, they have to share it with the Illinois State Board of Education. So those are our new updates now that we have for that, and especially that sharing requirement is something that we want to make sure people are aware of.
So we wanted to take a minute after we went over the new requirements to sort of just refresh everybody on procedure versus protocol. So the threat assessment procedure is what is required in the School Safety Drill Act. The procedure sets forth sort of three major areas that the school district has to make sure that they are addressing these elements. Basically on school-wide training and programs to prevent school violence, establishing the threat assessment team and conducting regular meetings of that team, both on a district-wide and a school-wide level. And then the final prong of the procedure is adopting a protocol. So the protocol is the actual document. It's similar to an evaluation document. It has different elements to it, different questions to answer, different things to fill out, different points where it refers you to look at records, to look at interviews with students, interviews with witnesses, interviews with people that might be the victims of threat. And I have a little visual aid. This is one example of a protocol. This is the University of Virginia, the Dewey Cornell model. But certainly the U.S. Secret Service has put out a protocol, and I know many of our clients have individualized protocols where they've had training. There's other models out there. I think the important thing is to make sure that you have a protocol and that people are trained on the protocol and that you know how to use the protocol and that you know the situations. I think, again, we started off with, I think a lot of people, there is, concern about this topic and renewed interest about this topic because we have these big events that like we cannot turn away from. They're so tragic and they're so horrible. But I think we also have to think about it like, how are we using this every day to identify conflict that could potentially become threatening, even if it's not in a global way? What if it's conflict between two students or conflict between employees and conflict between, people that are working together on a project? I think we have, as we have come back from the pandemic, and I don't know if this is just us getting sort of, I think as lawyers, sometimes we're a little skewed because people do not call us just to tell us how wonderful things are going. But certainly there's been a lot of conflicts where people are very, some of the behavior that results from the conflict is of a different sort that we've been used to seeing. And so I think really understanding that, while we might not go through every single page of Dewey's, 100+ page book, there might be other situations where we, say, let's call this student in, let's call these students in, let's do conflict resolution, let's talk about what's bothering them to try to de-escalate individual situations. I think the other area where you really want to focus on, other than, just the formal use of the protocol, is making sure that students are captured, especially students that might be struggling, and using those trauma-informed practices and your social emotional learning and how you're capturing kids that might have those needs as a corollary to this. So procedure versus protocol, it's required that you have a procedure. You don't want to make it part of board policy because you want to have the flexibility to make it fit your particular situation and evolve it, but you need some sort of protocol and training on that protocol. Amy's going to talk a little bit about what needs to be in the procedure.
Yeah. And so I'm going to break up kind of how I talk about this in two ways. One, I'm going to talk to you about what's required for the procedure. And I will, frankly, get through that quite quickly. Because if you look at the statute, there's really just some very basic minimum requirements that your procedure has to include in order to comply with the statute. So I'm going to go through those, and that is what's listed, here on the slide as well. But then also I'm going to talk to you about what some of the elements are, like what Dana went through, that we actually recommend be in your procedure in order to make it the most helpful and comprehensive for your teams. So in terms of what's required, the statute requires first that you have, we implement the procedure, and that procedure includes the creation of a threat assessment team. And specifically, the team has to include specific team members that are identified in the statute. You don't have to identify in the procedure these individuals by name necessarily, so long as it's by title. But the individuals that have to be on the team include an administrator employed by the district, a teacher employed by the district, a school counselor employed by the district, a psychologist employed by the district, or a social worker employed by the district. Now, with all of these, there's also the caveat that it can also be one of these individuals who's employed by a special education cooperative that serves the school district and is available to serve. But that's also a key component for each of these individuals, is that they have to be someone who the statute specifically says is available to serve. So someone where, that position is filled and that they are, prepared and able to be part of the team. The statute also requires that the procedure include at least one law enforcement official as part of that team. So that's what's required. to be included in your procedure. And that's it, which is why we have developed sort of a model procedure that includes, what we think to be really some more, consistent with best practices for how you might really develop these. So, before I get to some of those elements that we'd recommend, just to note, the statute does specifically state that as part of your implementation of the procedure, any sharing of student information does have to comply with FERPA and the Illinois School Student Records Act. So I know we often get some, a lot of questions about some of the nuances with regard to sharing and confidentiality information, both with the team as well as with parents, both of the, of a student who may have be the one alleged to have made a potential threat versus any potential targets or victims that are involved. And so we do provide some guidance and suggestions for that in our memorandum and procedure. And then, of course, the statute now does include those new reporting obligations. Now, I'll note for any of you who love going and looking at statutes on the General Assembly's website like I do each day, I will note that the new public acts that I just went through actually are not, they're not updated on the General Assembly's website if you actually go to look at the School Safety Drill Act. So you won't necessarily see those reporting obligations there, but those are in effect now. But so with that, so, if you just had the bare minimum of what I just went through in your procedure, you would comply with what the requirements are under the statute, and then we'll just need to share that with your ROE and law enforcement. But, we do recommend having, some more detail in your procedure, again, to make it as helpful as possible, as Dana went through. So, for example, we really recommend that your procedure address not only then how you will engage the threat assessment protocol that Dana just went through for when an individual threat is identified by or brought by a member of the threat assessment team, and how that process will go. We also recommend then including in your procedure, some sort of norms for the team in terms of when they will convene and how they will convene. For example, having a district level team as well as a school level team for your different school buildings, again, depending upon the size of your district, can be very useful and helpful to make sure that you're managing all the different issues that may come through. And then perhaps having, as part of your procedure, calling for how often those teams will meet. For example, having both the district team and the school team meeting on a monthly basis to review how the threat assessment team protocol is being implemented, and how that process is going, to make sure that that is effective when we need to be triaging in sort of an emergency day-to-day basis, that is working effectively. Those monthly meetings can also serve to review sort of on an ongoing basis updates of certain information of past assessments and outcomes, to make sure if there's any monitoring that was required as part of an initial determination from an assessment, that you're able to watch over those, and then just reviewing your procedures to see if any new updates need to be made, and then considering what your trainings are for both your team members, your staff, and any school-wide trainings, and really, if you have a system in place to be able to have those meetings and regular meetings to review that process, then you might both be hitting sort of a way to review your threat assessment processes from a high level on a regular monitoring basis, as well as then incorporating how you will handle sort of those triaged threat assessment protocol implementation, meetings as well, where there might be a smaller group of your threat assessment team that may be handling those on an individual basis. So having a procedure that identifies, these are the individuals by title that will be part of our district level team. These will be those who will be part of our school level team. This is how they will work together. This is how often they will meet. These are the things that they will discuss. Can be, something that we recommend, considering doing, and that is consistent with our model procedure. And then additionally, identifying within that procedure how particular potential threats will be triaged using your threat assessment team protocol. And having additional elements for what some outcomes of those assessments might be is also something that we would recommend considering doing. For example, if a safety intervention plan is one of the outcomes that the team decides should be done as a result of a threat assessment, having some parameters around what that might look like, including making sure that it's done in compliance with any Section 504 plans or IEPs as applicable, as well as other considerations is something, that we'd recommend considering, as well as having some understanding regarding how records will be maintained by the team, both the district level and school level teams, as well as your triaging team that's going through those protocols, to ensure that everyone is on the same page in terms of confidentiality of those records. So I know that was a lot, and frankly, our procedure actually goes through even some more details of what those things are that we'd recommend, but we wanted to kind of give a sense for, kind of how we recommend you really use this opportunity to have those procedures really help outline kind of the comprehensive way you're going to approach this as a district and as a school, even if the state law's requirement is very minimum, and then really making sure that your procedure and your teams understand, kind of that difference between that procedure in terms of the how it's going to be done and your protocols as Dana described.
So this is a great time before we start to talk about after the protocol, to talk about during the protocol. And there's actually a question in the Q&A about this that I did want to address. So the person's question is, guidance suggested including a social media scan in the threat assessment process. Have you seen this work successfully? So I have not seen this in use, although I've had social media come to light after a situation has occurred, and I think it would have been helpful to sort of know this before. It could have been preventative. So I think what people are talking about is when you are using the threat assessment protocol, at what stage would you review social media, either from the from the person who is the subject of the threat assessment, or if you're just reviewing social media generally, because a lot of times victims might come to you, or people that are being threatened, students that are being threatened will also come to administrators quite frequently with, I'm being bullied, or this is what's happening. And this is such an interesting thing. And obviously this is something that's been reported in the news about people having a social media presence, and there were warnings that this person was engaged with, certain groups or certain activities that were, definitely foreshadowing that something like this could have occurred. But I think the question is, when do you do this? When do you do this in the protocol? If you look at just sort of the Cornell model, that would probably come when you're doing an individual threat assessment and you're starting to review information about the person who's the subject of the threat assessment. And there's categories in the assessment where you evaluate, like, has the person undergone stress and trauma? Has the person had do they have access to weapons? What's their mood like in school? You might add a category there, do we, want to look at their social media presence? The difficulty with that, though, is how do you do it? And, a lot of students do not use their real name when they're posting. How do you connect, what those postings are to that student? And sometimes, in some cases, that's going to require a degree of expertise. So I think it's something to think about. And that actually is an example of what the district level threat team should be speaking about and what they should be doing. It's these large topics, looking at the protocol. Is the protocol robust? Does it meet the threats that we're seeing in the community. Another thing that just sort of came to mind, and I know Amy was present at this meeting too, but we have colleagues that work with law enforcement agencies. And I do know that law enforcement agencies are starting to create divisions where they track social media things, and that helps them look at where there's going to be gang violence in an area, where there's going to be other incidents of violence, and they follow those. So that is emerging, technology that's being used by law enforcement and may someday have an impact in schools. So looking at after the protocol, you've done your threat assessment protocol, you've determined that there's a threat, or maybe you've determined that there is not a threat, an immediate threat. What do you do next? And there's many ways, there's sort of many branches that this can go off into. I think the first branch, which is always the place to start, because I think this should be the underlying, reason you do this, is intervention. And intervention is separate from discipline. Intervention means, what can we do right now, both practically and in terms of capturing the students and capturing their needs and addressing their needs to prevent the threat. So it can be anything from safety plans, it can be separating people, it can be doing conflict resolution systems, whether it be mediation, some sort of peer conflict resolution methodology. It could be intervening with employees and doing some mediation or problem solving with employees. It can be referral for service for a student who maybe is struggling and is isolated. I was at another presentation, not to do with this, but this sort of metaphor came to light, and it was like, you need to listen to the whispers so you don't have the roars. And I think that's a good sort of model for intervention. Where do you hear, where maybe there's not an active threat right now, but you've really identified that there's a student who's isolated and who has a problem connecting and has none of these sort of supportive factors that are identified in the protocol that mitigate the risk of threat. Those factors aren't really solid, they're not present. How do we talk to parents? How do we get those interventions started? And then part of the intervention, if it's a serious enough threat and something occurs, could be discipline. And Amy's gonna go through some of that.
Yeah. So Dana did a really nice job kind of going through all the different things that you might consider following an assessment, depending all on the nature of the circumstances, the student, and how you have assessed actually that potential threat, right? As Dana said, if you've assessed that they're actually determined that there actually was one, how substantial it was, that's all going to factor in. You very well may have a determination following going through your protocol of outcomes that you've determined that do not include discipline. And so that, there may be many circumstances in which you don't find it to be appropriate to issue any discipline, but to do other steps. That said, if you do find in a certain scenario that discipline is appropriate and warranted, we do need to make sure that to the extent that any of that discipline includes any out-of-school suspensions or recommendations for expulsions or alternative placement, that is done in accordance with Senate Bill 100. We do not currently have any sort of mechanism for schools to exclude students just due to a safety threat assessment issue without complying with Senate Bill 100 in terms of our suspension and expulsion, requirements. In terms of just our regular students, we need to make sure that we're complying with those. So again, if you're considering issuing any suspensions or expulsions, then we need to be considering those criteria. If a student's continuing, it has to meet the criteria if the student's continuing presence poses a threat or substantial disruption to the school environment. If it is a longer suspension or recommendation for expulsion or alternative placement, we have to make sure that you've made a determination that all available and appropriate interventions have been exhausted. So those are things to keep in mind, as you would at any time that you're considering any exclusionary discipline, if you find that to be appropriate.
So going into, and I want to move through this pretty rapidly so we can get to the clear and present danger part here. But one, I think two very important things after the protocol are parent contact. You need to plan this to be another meeting for your district threat assessment team. I know we've done some samples for different clients, but how do we tell parents that either their student has been, there's a threat against the student, or how do we tell parents that their student is involved in a threat? And if it's not through the discipline process, or we have like worries about a student. And I think this has to, you have to think about this very carefully, because I see so many times when we do this process, we get complete shutdown of the parent. And while I think, part of that is to be expected, and you've got to do your duty and follow through with this, regardless of what the parent's reaction is, I think we need to start thinking about how we can sort of prevent that complete shutdown, because that complete shutdown doesn't lead to any good interventions, really sticking with the student. And I think that comes from, contacting parents about this generally. Like, this is what threat assessment is. It is not to identify, 7-year-olds as potential serial killers. It is to sort of look at your children's development. Are they developing emotionally healthy connections to others so that they can be productive in a workplace? They can be productive in a family relationship. They can be productive in society and take part in things. So I think planning out that contact and ahead of time is really important. And then I'm going to let Amy wrap up with clear and present danger, and then we'll take a few minutes for questions, but I know we're about done with our time.
Yeah. So, again, we talked about earlier, just, you want to keep things in mind in terms of how you're going to be keeping and maintaining your documentation for your decisions that you're making. And then one of the outcomes, that may also, you may arrive at is if you do find after you've gone through your protocol that you make a determination that a student does pose a clear and present danger to themselves or others, then that may trigger the obligation to make a report to the Illinois State Police that you have in fact made that determination that a student poses that clear and present danger. So again, that is something that you would do following that determination. And the law requires that then you make that determination or make that report within 24 hours of making that determination. So we always want to, remind people that this is a very important and critical reporting obligation that you take if you have made that determination, but also that this is not a emergency response step to take either. So you want to follow all of your emergency response protocols that you typically would do and your threat assessment protocols. And then upon making this determination, if that is the case, which you may not always have following your going through your threat assessment protocol, but if you do, that's when you would make that report to the Illinois State Police using their form that they have on their website. Remember that the purpose of that report is for the Department of State Police or the Illinois State Police to then review that to determine if that gives grounds for the Illinois State Police to prevent someone from getting a FOID card or revoking the FOID card. So that's the purpose of that, and something that then you would make again if you found that determination has been made following the protocol.
And considering that purpose, I think this is something where we get a lot of questions sometimes from elementary school districts, and the clear and present danger reporting, while it plays a factor and it's something you should consider, I mean, you also need to use a little bit of judgment about what the purpose is. Like, if you're dealing with a threat and the kid is 8, you're really, before you even get to clear and present danger, I mean, an 8-year-olds do not have very much agency. We're going to assume that they're not, going to the grocery store, driving around, communities on the loose. But you are going to take that in a different direction. And if you really are concerned, and unfortunately we live in a world where sometimes we really are concerned about kids that young and their access to weapons, you're going to involve the police right away to, work with you to go to the home and discuss access. Does the child have access to weapons? And it may be a different type of clear and present danger report after you get that information from the police. It might be something to do with, or it might be a different kind of report. It might be abuse or neglect or a student not being properly supervised in the home. So, I don't want people to have the impression like this is a very important obligation, but we're also not like finishing a threat assessment, deciding that a 9-year-old is dangerous and then going right to a state police report, because the likelihood of that having any significant impact when the 9-year-old can't even purchase any firearms for another 9 years, and no disrespect to any agencies and their record keeping, but 9 years is a long time for something to have an impact. So something else, to think about as you do this, there's other things that you might want to explore that might be more significant rather than that report with a very young student.
And it's really so important to keep those considerations in mind. If you do find that, of the steps that you need to take following going through the threat assessment protocol, that is one of the things you need to do is to make that report. We do get a lot of questions too, often about some of the nuances with regard to that report making and the information that should be included in those reports. So, please feel free to contact us for support with regard to that, but we wanted to discuss it briefly here to explain sort of how it should be viewed in the context of your overall threat assessment process. So, we really appreciate your engagement today, and those of you that submitted questions prior to the webinar and during our webinar. Please don't hesitate to reach out with any additional questions on things we weren't able to get to today. If you're interested in hearing more about the model procedure that we went through, feel free to reach out to us as well. So with that, have a great afternoon. Thank you.
Thank you.